So the president once again facing the possibility of standing trial. Let's discuss. Let's look at the legal arguments. We're joined by Professor James Grant, visiting associate professor of law at Wits University. Professor, thank you for being with us. Firstly, this is 9 years later, 9 years worth of advocates' bills, which I know can be pretty steep. Should somebody be made to pay for what seems now perhaps like a huge waste of time?
Yes, I believe that somebody will be made to pay. And of course, the court could always call on Jacob Zuma himself to be made to pay. And they could, as the Constitutional Court did recently, call on him to explain why it is that he shouldn't bear the costs of all of this. Other than that, of course, we would see the usual, which is that the costs would go with the decision, as was spoken about in court today, which means that the losing party bears the costs.
What about Mkotedi Mpshe? I believe that you know him. What sort of responsibility does he bear for an irrational decision? And do you believe that he would actually still stand by it? Well,
I work with him. And what I can say is, my understanding is that, the difficulty, of course, is that he wasn't called on to depose to an affidavit. All that he was asked to do, which is indeed what was presented before the Supreme Court of Appeal today, was to confirm an affidavit where his side of the story, or their side of the story, as the NPA, was set out in an affidavit by Willie Hofmeyer. And he did indeed confirm that. Insofar as whether he could be shouldered with any of the responsibility, I suppose the question must be asked whether there is any suggestion at any point of him having made this decision with any form of male fide or bad faith in any way. I suppose if that is the case, then there could be questions which arise. Having made an irrational decision doesn't in and of itself, I think, raise those questions.
And he may have believed he was doing the right thing. Just explain the broad strokes for us of the law here, where sometimes the matter of innocence or guilt can be downplayed if it seems like justice officials acted inappropriately or there's been gross injustice. I don't know, there's cases in the US, double jeopardy, you can't be charged again. Here there was a bit of manipulation of the timing, but it seems like everybody agrees not enough for the charges to go away.
Absolutely. I think that that's been the point all along, is that there has been a suggestion of some degree of impropriety. There have been different views expressed as to whether impropriety at all should be allowed to feature or have any effect. In fact, we saw the Supreme Court of Appeal in, I believe it was 2009, in the judgment handed down by Harams for a unanimous court, saying, it doesn't matter whatsoever. Whatever form of impropriety there is, the question that remains is whether there is a substantive case to meet. And I'm not entirely convinced that that is truly a proper reflection of our law, because if you read on in that very same judgment, you will find that Harams himself seems to take account of the proposition that improper motive may undermine an investigation or a prosecution. And that has led us down a very long road, which has been most unfortunate, to the point today where we have finally heard the two leading advocates concede that, in fact, while there might have been impropriety, it's nowhere near what ought to have, the sort of impropriety that could qualify as leading to the dropping of charges.
Those very same lawyers are now taking a different tack, and they say that the president would like to make representations to the new NPA head, Shaun Abrahams. So presumably those would have to be pretty compelling and linked to the matter of guilt or innocence. What do you believe are the chances of our president facing a trial?
very strong. I think the chances of the president facing criminal charges have always been very strong. It's just the question of when. And I think he's been very successful in delaying it as long as he has. And I wouldn't be surprised if he manages to delay it even further. I expect that his lawyer, Advocate Kemp, will be successful, or let me rather say may be successful in his submission that if the court is going to find that the decision which was taken was an irrational decision and is void, then it follows, of course, that nobody has really decided on the representations that the president has made. And therefore, he's asking whether he can once again make new representations. I think that follows logically in law, and it would be only fair. Whether, in fact, the national director could possibly find that there's no basis on which to proceed, given, of course, what the courts over time now have told us, that it's irrational not to proceed in the circumstances, I doubt that the national director could decline to prosecute. And of course, there's the other point, which is that if he does decline to prosecute, there is the institute, which is being headed by Gerrie Nel, waiting for him to declare his intention not to prosecute so that they may pick up a private prosecution.
So there will be a trial then regardless. Sean Abrahams, you've touched on this, that he has come under fire. A lot of public distrust. The National Prosecuting Authority went with the man they are now going to perhaps prosecute to court to try and stop this all. What did you think of that behavior in the first place?
I've always thought it somewhat regrettable and questionable how the NPA could have ever decided that they shouldn't prosecute him from the very moment that it was declared that there was a prima facie case, and but that they wouldn't proceed with it. That in itself was very peculiar, and that began the saga as far back, I believe, as 2003. We saw very strange decisions around this. And, of course, following that, the partner in crime, so to speak, Shabir Sheikh, was convicted. And nevertheless, Zuma wasn't prosecuted. And finally, when the decision to prosecute was taken, it was withdrawn in the most peculiar of all circumstances. And so this has been a most regrettable saga in our criminal law, and one can only hope that the NDPP sees the opportunity now to correct the justice system and to correct the damage that this has done.
I think many South Africans would concur. Thank you very much for your time this evening. That was visiting Professor to Wits James Grant, looking at the legal side of things, and then, of course, there's the political